The rest of the family categories are not immediate. They're called preference categories, and for each of these there is a backlog. So if the unmarried adult son or daughter is being sponsored by a U.S. citizen, they're in the first preference category, and the backlog right now is about 5 years. The 2A category is backlogged similarly about 5 years. 2B is backlogged about 7 years. The married son or daughter of a U.S. citizen is backlogged 8 years, and the sibling of a U.S. citizen is right now backlogged about 11 years. These go up and down by what the number of people in line who decide to go forward, who are qualified, and who take a number out of a quota, which numbers are released annually on October 1st. So they release those numbers. If there's 10 available and 10 people come forward, the quota is backlogged starting with the issuance of the 10th visa. It's actually in terms of thousands, but once those visas are used up, no more numbers are going to become available till the next October. These are the categories that everybody keeps saying everybody should get into, and that anybody who jumps these categories is really breaking the line. First of all, the line is not very comprehensive. It also, as I will explain, doesn't cover people who are gay and are in married relationships. But also, the numbers are so backlogged that some people, in effect, say, I can't wait 11 years. They're doing something wrong to jump the line, but it's not a very effective line. This is part of the reform that's got to come, is to determine whether to expand this in numbers, whether to expand it in relationships, and also when we go to the business side, whether to expand it somewhat. The preference categories can adjust here only if they are always legal. They can never violate status, they can never work without authority, unless they go back to an old Clinton law they call Section 245I. It's a peculiar piece, but anyways, there's one little exception that's available for some people. And this was the preference category quota stuff. If you go to the Department of State's website and look at the visa bulletin, it is changed every month to let you know how they're moving through the categories. So if you are an immigrant yourself and you want to follow this, you can do it. It's a public document, and watch on the visa bulletin as the lines move. So if I'm a permanent resident and I file for my daughter and she's waited 8 years to come in, when the date on which I filed for her is at the top of the visa bulletin line in that category, the second preference, 2B category, she will then file an application for permanent residence based on my sponsorship. If I'm straight and I'm a U.S. citizen and I file for my wife, I'm an immediate relative. She's an immediate relative. We don't wait in line, and she applies for her application for permanent residence at the same time I file my petition for her. My wife, if she's applying as an immediate relative, my daughter, if she's applying as a preference category, had to file, still does, a medical exam from a government-appointed doctor as part of the application. And again, that's where the HIV waiver was triggered. If she was HIV positive, she could only get the waiver if she had one of the anchor relatives. There was no humanitarian basis for the waiver. Again, that's gone. Now, no other relatives can sponsor. No aunts, uncles, nieces, nephews, etc. And same-sex spouses are not recognized. Adopted children have to be adopted before the age of 16. So if someone really wants to adopt their boyfriend when they're 25 or something, it's a little bit too late. We get those questions all the time. They're actually sort of fun to answer. I mean, it's sad, the result is sad, but the give and take is fun. It's people trying to get through a lousy law by coming up with creative responses for good relationships. Stepchildren are also, and step-parents are covered as long as the marriage creating the step relationship occurred before the child's 18th birthday. So below 16 for adopted, below 18 for step.